Good everyone. Good evening, everyone. I hope everybody's doing well. Just wanted to get together with you tonight and go ahead and present the personnel law information. There's a lot to go over. I'm not going to read you the stuff that's in the book. Obviously, that's what you're supposed to be doing, and I'm going to just go over some PowerPoint presentations fairly quickly. Some of these have been built by Michelle Morris, our attorney, and personnel is what I do on an everyday basis here. And when I took over personnel several years ago in HR, I got it. I wanted to get into it because of the fact that it just seemed like a really interesting job. It seemed like you're hiring people, you're putting great teachers in place to teach our kids. What you don't know is there's a downside to HR that teachers do very few teachers do stupid stuff that gets them in trouble, and you have to deal with investigations, potentially terminations, and that's just not fun. It's horrible actually, and also having to deal with the last 5 years with the economy, budgets. And we're actually kind of dealing with it right now with a Senate budget and a House budget that are opposed to each other in North Carolina. When you got the Senate budget wanting to cut teacher assistants, but it also cuts teacher positions. In our county, we cut 120 teaching positions. And then you've got the House budget doesn't cut any positions. So, and we've had to move people around, reassign people, and dealing with the RIF policy, reduction in force policy, is it's just not a good thing to work with. When you're dealing with people's jobs, it's hard to work with sometimes. But the law is there to help you as a district for fairness, to meet people's rights, and to have a process for potentially moving people out. So I want to talk about a little bit about contracts. I want to talk about discrimination. I want to talk about torts. Talk about employees in general. Okay, and I'm going to start off with, I think, discrimination. And let me kind of pull up here and show you this. Share this page with you here. Here we go. We're going to go to the beginning here. Okay, this is a different person who put this together. I'll just go over it with you. Okay, legal context, extending constitutional protections. 14th Amendment, we'll really talk about Title 7 of the Civil Rights Act, deals with those things with discrimination. 14th Amendment, no state shall deny to any person within its jurisdiction equal protections of the laws. That's one of the ones you see in court cases all the time, equal protection of the laws. Title 7, enforced by the Equal Employment Opportunity Commission. If somebody doesn't get hired for a position, or is that's what I've dealt with the most, is when you haven't gotten hired for a position. Typically, they'll use race or gender or age, and I've had a lot of age. And recently, I got one just came out on a gender case. It was really a termination, not a hiring. But you have to go through this process. It takes sometimes months to complete a process with an EEOC complaint. But that's under Title 7. Okay, I'm going to send you these videos so you have them. Excuse me, PowerPoints. Disparate impact applied when an employee's ostensibly neutral practice has a discriminatory impact on the class the claimant represents. To disprove disparate impact, the plaintiff is not initially required to support discriminatory intent, but must establish that an employee is Facially neutral practice had a disproportionate impact on the plaintiff's protected class. What does that mean? Basically what that means is we have practices in a county, and that practice has more of an impact on on race, or that the impact that practice has a greater impact on gender, one gender over another gender, that could create a disparate. And let me back up. And the district doesn't do anything about it. That could create a disparate impact. Okay, retaliation. Response to filing an employee may not be terminated, demoted, or harassed. If action behaviors occur, the employees can file a second claim of retaliation. You have relief. We've got in hitting this part. I'll include that for you. So these are just a variety of the things you'll see. I mean, you're dealing with discrimination. You're dealing, again, generally with a class of individuals, whether it's race, sex, age, national origin, religion, all these types of things. And so you have to have your policies and practices that, one, you have to state as a district that you don't discriminate based on these variety of things, and two, you have to always look at your practices, because you might not see it this year that a practice tends to impact one class of individuals over another class, but later on, over time, that might happen. And I would say every district at one time or another have things in place that tend to impact. It's not intentional, it's just it happens. Okay, so these are some variety of things, and I'm going to go on out. I'm trying to see if there's anything else in here that's. I'll send you this. I think it's a lot for you, but I think it's basically that's the tenor of it is the different classes of individuals and the impact. Okay, so we pull up one that's similar. This is by Michelle. Civil rights, to see if there's anything new in here. Talked about the procedural, due process. Right, when due process and when you're dealing with employee issues, just like a student, they have due process. Due process, notice of charges, same thing. Prompt hearing by an impartial tribunal. That would be your Board of Education. Lots of Board of Educations with student discipline. You can break it down into groups of board members. You know, like it's an odd number of board members. But when you're dealing with employee laws, that's the entire board has to hear those. I don't know if you saw it. Let me go back here. I'm going to go back here. Here's the due process one I was just talking about. And I'm going to skip down. Let's see here. Okay, we talked a lot about public forums before, so I'm not going to get into that. And I think Michelle does a good job of explaining the different public forums here. Remember, we're in generally a limited public forum is that we're dealing with in the school system. The point is, I think, with this is that your employees sometimes will say things in class, say things outside of school that some people might believe that they should not say, and so it gets real sensitive, especially today we're dealing with Facebook and we're dealing with Twitter, and sometimes teachers might be upset in a situation and say something on Facebook. I had a teacher put something on a Facebook last year, which was a confidential matter, and when it has a nexus to the school, when there's a connection to the school, that's when they begin to cross the line. Now, when they can say they have their opinion on things and their rights are protected by the Constitution, generally other things, unless it's got a nexus to the school with it. Let me see if there's anything else. All right. Just the statutory protections. You got an Equal Pay Act of 1964, Civil Rights Acts of 1964, Title VI, Title VII, Title IX, education, that's the one we dealt with, gender, ADA, Americans with Disabilities Act, those types of things that the federal government is highly protective of and should be. Okay, I'm not going to go over. I'll let you read those on your own. This one at the bottom, hostile work environment. This is one, I know it's dealing with sexual harassment, and sexual harassment is something actually we've been dealing with a lot in Union County over the last 3 years. We actually had a OCR, Office of Civil Rights, complaint at one of our schools with a situation with students. And so we've done a lot of training with sexual harassment. If you haven't had training at your school, by your district, then that will come one day, because it should be ongoing training every year discussing about it. It really deals with unwelcome sexual advances, sexual comments, sexual touching, that should be reported, must be reported, not should be, must be reported. And a lot of the cases you have to involve law enforcement, and it's reported to the Title IX coordinator. In my district, I'm the Title IX coordinator, so everything that is of a sexual harassment nature, whether it's student, whether it's teacher, whether it's a contract worker that comes to do construction work on the campus, whatever it is, if there's anything that's unwelcomed, it has to be reported to my office, and there are certain steps that have to take place. A lot of times what I deal with work environment, when there's a situation where a teacher is not getting along with other teachers, or a teacher's not getting along with a principal, I get the hostile work environment that's thrown out at me that I have to investigate when that verbiage comes out. And so I always try to stress to principals about the fact of, try to, document things, but be positive, be professional. If you've got questions of how to handle a situation, to call us up, we'll work with you, because we're going to try to keep you out of those types of situations whenever possible. And I think, let's see here, if there's anything else. There's a lot in here, but I'm just going to go over over that right now. Okay, so let's see what we got next. Next, we're going to go to, I think I'm just going to work with you on this, is talking about contracts, and then we'll talk about leaves of absences, and then torts, and and then those things that we have to deal with, terminations and everything else. So generally speaking, I'm just going to speak about North Carolina. North Carolina, when hired, you could be hired on an interim contract, which that means that there's an end date to that contract. You could be hired on a provisional contract stating that, let's just say, for example, you want to be an assistant principal. When you start your classes as an to be assistant principal, like what you're in now, you can actually become an assistant principal in the county if they allow it. In my county, you can become an assistant principal while you're working on your degree, but you have a provisional certificate, provisional contract. So in other words, you got to get your license. You got to continue to work towards it, and you've got to get it. You've got probationary contracts is the really big one. You're talking about early on in their first 4 years, they have probationary contracts, is what we did have, and then after the 4th year, you could get career tenure. Now that's gone away with the General Assembly last year. Now the only thing we've got, you've got interim contracts, but you have either tenured contracts that teachers have already been tenured, and tenure doesn't exist anywhere else for anybody at this point, except those who had received it. prior to last September, or one-year contracts. Unless something changes, that is the law of the land in North Carolina. So that people that are being hired right now, they'll continually have one-year contracts again, unless that changes, or whether the lawsuit, the lawsuit said that they did not allow one-year contracts, probationary contracts, to go back into a place where they're working towards 10 years. So it's just those two things at this point in time, unless the Senate or the General Assembly changes their mind on that. So the contracts, you are hired by the Board of Education. You're not hired by a principal. You're not hired by a superintendent. You're hired by the Board of Education. The principal can make a recommendation. The superintendent can make a recommendation, but it's the Board of Education that approves that. And the Board of Education has the authority by the state of North Carolina, the hiring authority, to do that. The Board of Education also determines what you teach and where you teach, as long as you're teaching within your certified area. A lot of superintendents generally have it in their contracts that they have the authority to reassign teachers or staff members as necessary for the needs of the district here. But that's not necessarily in every contract by a superintendent. In my county, the superintendent does have that authority. There are other things that once a teacher is hired, there's obviously state benefits, policies, and things like that, but leaves of absences, whether it's for educational leave, whether it's for short-term disability or medical leave, those types of things are also approved by the Board of Education. They generally are worked on through the HR department. You build calendars for teachers, but the request for leave have to go to the Board of Education, and must have an end date as to when that person should be coming back. And that's generally what the board deals with as far as non-disciplinary things with employees. Those two things here. Recently, we've been dealing with the 25% contract, which has now been determined to be unconstitutional. I spent my entire year working on that. I had my whole team putting that together, getting ready to present those to the Board of Education when it was determined to be unconstitutional. I have no problem with the ruling, and but you know, it did pull a lot of resources for something that just didn't ever happen. So now let's talk about things that get teachers in troubles here, and I'm going to go ahead and pull up for you. It's not up here. Let me see if I can get it up. There we go. Torts. Okay, torts are these little things that happen when teachers do things that they shouldn't do with two kids. And a lot of the things I deal with tend to be things that is not meant to be a tort. A lot of times, in some cases, it's not really a tort. What's happened? It's perception that there's a tort claim. And so, what is a tort? To tort is we're really our job is to protect children, and these are things such as hitting a child, defamation, libel, and we talked about that a little bit last week. So a tort is a wrongful act or failure to act that causes a person injury or damage to a person's property or reputation by someone who has a duty to act for the safety and protection of that person. You can get the relief for that is compensation, monetary compensation, financial loss. For financial loss is medical bills, such as things, and there can be there are other types of damage remedies that are available. The three types of torts you have: intentional torts, negligent torts, and strict liability torts, which includes injuries or harm resulting in inherently dangerous conditions or activities. For example, the use of explosives or hazardous chemicals. Strict liability torts are generally not an issue for the school. So we're dealing typically with intentional torts or negligent torts. Intentional torts we'll come to next. Intentional torts are those willingly or knowingly. So there's assault and battery, false imprisonment, libel, and slander. They can cause injury or harm to someone. The intent is required. The intent required is the goal to do the act, not necessarily to injure. Also, the person who commits the intentional tort is liable for both the intended results of his or her actions or the unintended results of his acts. So we've got those. We've got assault and battery. Assault is the unlawful threat. Battery is the actual touching without consent. Now, that's a little bit different in North Carolina, and I'll tell you why in just a minute here. The touching must be intentional, but no intent to injure is required, and no actual injury is needed as a result. Assaults against students by school personnel. 2 North Carolina statutes address the use of physical force. North Carolina General Statute 115C-390 states, except as restricted or prohibited by rules adopted by the local board of education, principals, teachers in the public schools of the state may use reasonable force. That's the key phrase there, reasonable force, in the exercise of lawful authority to restrain or correct pupils, maintain order. My superintendent, my last superintendent, would basically say there are only 3 times that a teacher should touch a student. And I know we're not talking about kindergarten teachers here, but in general speaking, I mean, kindergarten teachers, the reason I say that is that kindergarten students just love to hug teachers, and that's part of the kindergarten, first grade, second grade type of thing. But beyond that, 3 times you should be touching a student. 1 when the student's harming himself, 1 when a student's harming others, or 1 when the student is committing some type of damage to a school, like throwing rocks to a school, or something like that. Those are the 3 ways. Okay. And there's really the specifics to that beyond my superintendent, the exact laws that cover that. And to quell disturbance, threatening injury to others, to obtain possession of weapons or dangerous objects, for self-defense, for the protection of persons and property, to maintain order on the school property in the classroom or school-related activities or off-school property events. The other one that's allowable is corporal punishment, although a lot of districts in North Carolina have banned corporal punishment in their schools. There's obviously a lot of controversy with regards to corporal punishment. Assault and battery against school personnel by students. Attacked by a student, school personnel may exercise the right of self-defense. North Carolina law allows school personnel to use reasonable force, there's a phrase again, to protect themselves from death or bodily harm. The use of deadly force is not permissible in self-defense if the attack does not reasonably threaten life or create the potential for serious bodily harm. The employee also has the right to pursue civil suit or criminal complaint. Okay, this is assault and battery by students on students. A student victim of an assault or battery made by another student has the right to file a civil suit or criminal complaint against the other student. The student victim may also sue the school, sue individual school employees, and this is, you may say, why do that, or the school system, if the personnel failed to provide protection from the acts. The foreseeability to harm students will be determined the degree or liability of the school districts. If you could foresee that these 2 students may harm one another to the point of injury, or if they harm one even another, you have a responsibility to get there in the middle of that and stop that, period. Doesn't matter who you are, what you do in the school system, you have that responsibility. Defamation. Defamation is intentional tort of damaging a person's reputation by false statements. The false statements must tend to result in contempt or ridicule, damage to the reputation in the community, reduce the respect among peers. The statement must be a statement of fact and not opinion. There are 2 types. There's libel and slander. Libel is written, slander is oral. We talked about that a little bit last week. All right. And I'm going to go. All right. Let me stop there. There is something for privileged communication, reporting child abuse. You have a responsibility. We all have a responsibility. If we believe that there is child abuse taking place, we have a responsibility to report that. Your principal may say you're not going to do anything except report it to me, but you have a responsibility by law. You have the responsibility to report that, and I would follow my recommend. I would follow and let the principal know those things, but to recover yourself, to protect yourself, I would report those to DSS, and that is privileged communication there. Although we all know that somehow parents tend to find out, you still have that responsibility, and you're protected by law. The other one is employment references. If you're placed down, that's the other one. All right, I'm going to keep going here. Negligent torts. Negligence is, there are 4 elements here. Duty of care. Okay, so you have a reasonable response. We have a reasonable person, excuse me, we have a standard of care that a reasonable person of ordinary prudence would exercise. To be a negligent tort, there has to be a failure to conform to that standard of care. Proximate cause, there's a reasonably close causal connection between the action and the resulting of injury and the actual loss of injury. And then I'm not going to read these. I'll leave these for you to read yourself. But they're worth reading to understand these torts. Okay, there's that foreseeability again. Okay. Negligence is probably the one we tend to deal with the most as far as negligence, as far as this particular tort goes, because things that happen, whether it's in school during the day or out at home, where we do things or and don't intend to harm somebody, but we're not watching close care over a situation and injury happens. Had to deal with injury on a school premises when I was a principal, actually, with that went to mediation with regards to a construction site and situation that where a person was injured, and we had to. It takes a few years to go through and deal with that particular type of case. Okay, this is all good stuff for you to look at. I'm going to just keep going though, for sake of time. Okay, you've got defense for torts. 2 types of defenses: a denial of one or more elements. B, affirmative defense, which presents a reason why the plaintiff should not be allowed to recover even if the allegations are true. Examples: the statute of limitations has expired. There is governmental or statutory immunity. There is statutory limitation of liability. The plaintiff was contributory negligent, or the injured party signed a release or voluntarily assumed the risk of injury before participating in the activity. And then they talk about these things. I'll leave these for you to look at. Contributory negligence had a situation we dealt with before in my district, and I think this kind of covers everything there. So that is some of the things that you can get in trouble for, or an employee can get in trouble for, that you might have to deal with in my particular situation. And then let's see here if there's anything else that I've got for you. I think that is about it for PowerPoints. All right, I've covered reporting child abuse, personnel laws. Okay, so I'll talk about personnel records, and then I'll get into what can happen with the states, the statutes. Well, I'll tell you what, I'll do the opposite, so we just did the torts. So I deal with investigations about a daily matter. They they could take an hour to deal with. They could take 3 months to deal with, and they're all over the place. So the things that generally I tell people when they come into me, there are 5 things that occur. One is he said, she said. We can't prove anything. This is just how our practice is a memorandum of record. 2, the environment was right for something to occur, but we don't have proof that it occurred. And that's generally something where we work with a caution. Again, it's our own practice. Number 3, 4, and 5, the event occurred. The third one would probably the third one is we know it happened. It's a reprimand that goes in somebody's personnel record. Which is talked about in state statutes. The next one is a suspension without pay. Now, you could do a suspension with pay while you're investigating. You could do a suspension with pay up to 90 days. But the suspension with pay requires the Board of Education to approve that specific amount of time. And then termination. Okay, so let's talk about a teacher that is potentially going to be terminated, okay, for something. Generally, while we're doing the investigation, we will suspend them with pay, and I've gone up to 90 days on an individual at some points, and then we bring them in. I generally give them their due process on the event that occurred. Then that's usually it's about 3 times they come in. Then I bring them back in and basically say, listen, there's a possibility that I might have to move towards a notice of charges. And sometimes that's more of the second due process, but also kind of lets them know what could happen and what's other options that they may have. They may want to take another route, because the last one is the recommendation for termination. I have to do notice of charges for that. It's just like it's reading charges, like reading when somebody gets arrested, they get charged against them. I go through all those charges, I read all the statutes, and then it has to go. They're required to go to the superintendent and present their case to the superintendent. And if a child hasn't been harmed, then a lot of times I will give them the opportunity before it gets to the superintendent to try to allow them to save-face resign. They don't have to put that on their application that they've been suspended without pay. They don't have to put in their application that they've been terminated. And generally speaking, I can have a pretty good number of cases that I've dealt with that way. But once it gets to the superintendent, she still has the right to let them resign if she wishes to do so. But once she makes the decision for termination, they're immediately suspended without pay, and they are immediately given the opportunity for, I think it's 14 days, to determine whether they want to ask for a hearing with a mediator, or ask for a hearing before the Board of Education, or do nothing. The superintendent will take it to the board, and sometimes again she allows them to resign. And then after that, it typically goes to the Board of Education or the hearing officer, then back to the Board of Education. Never had to deal with a hearing officer. I dealt with the Board of Education termination. So these are the things that can happen. 115C-325 is the general statute that talks about personnel, that gives you the 15 reasons that you can terminate an employee. Important for you to look at. That the tenured teachers are protected by those 15 reasons. And a teacher who is not tenured, the one-year contracts, during their contract year, they're protected by those 15 reasons of 115C-325. After that 1 year, that one-year employee, we can terminate them for anything as long as it's not arbitrary, capricious, it's not discriminatory, for any reason, good reason that we have. And there are some other state statutes. One dealing with the well-being of students to supervising students. That can be used a lot of times in charges. A lot of the charges that we put in our terminations have to do with the ethics codes violations, insubordination, but insubordination is also in 115C-325. And then finally, personnel records. Personnel records are generally protected. It's confidential information. Names, demographic information is not confidential. You know, how long you've been there, work for a school system, your name, those types of things. In the last 4 or 5 years, it may be a little bit longer than that, if there's been a demotion, if there's been a promotion, that those things are no longer protected by, if somebody will request those records, they're no longer protected by the confidentiality that they once had. And but when you get into things like investigations, then that is protected information. If you also, with personnel, you have, let's just say somebody's got a medical situation, medical records that we have and personnel records, they can't go in the same file. They actually have to be kept in separate files. So there's the reason for that. It goes to the potential for ADA discrimination, and that's state law. Well, folks, that kind of concludes tonight. That was a longer night for you, and so I'm going to close this out. I'll send it to you. I'll send you the PowerPoints, and I'll see you tomorrow. Thanks. Have a good night.